Reliance damages. So far we have discussed why expectation damages are preferred and why this is efficient, but sometimes expectation damages, which are either the diminution in value from the breach or the cost to cure the breach, plus other loss minus loss avoided, cannot be calculated with reasonable certainty. Or the injured party has spent more money in reliance of the performance than either the diminution in value or the failure to perform. That happens when someone has made, for example, a bad deal. And in the Best Buy example, even though the profit from the TV would have been $200, they spent $300 on advertising, and now they want to collect the $300 and not the $200 because that's their reliance damages. In these cases, courts may award reliance damages, but not frequently, which is the amount of out-of-pocket costs the injured party incurred based on a reasonable belief that the contract would be performed. Reliance damages are the amount of out-of-pocket costs an injured party incurred because of a reasonable belief that the contract would be performed. And so reliance damages would put the party back in status quo to essentially refund those out-of-pocket costs and put the party back in the position they would have been in had the contract never been made and they reasonably relied on it. According to the Second Restatement of Contracts, an injured party may seek damages as measured by actions taken in reliance instead of diminution in value as a result of defective performance or cost to cure, but in practice the remedy is quite limited. For example, imagine, as I mentioned a moment ago, that Sony agrees to sell TVs to Best Buy for $500. And Best Buy plans to resell it for $700, getting a $200 profit. But in reliance of this TV sale, Best Buy launches an ad campaign, which because of poor cost control ends up costing $300. And so they're expecting to lose $100. And so what they really want is to be put in the position they would have been in had the contract never been made, because if the contract were performed, they lose $100. Best Buy should not have tried to spend $300 in order to earn $200, but such things happen. Is Best Buy going to be able to prevail in getting reliance damages instead of expectation damages, because reliance damages are greater than expectation damages? No. Judge Learned Hand summarized this in the case of L. Albert & Son versus Armstrong Rubber Co. Quote, "We will not in suit for reimbursement of losses incurred in reliance on a contract knowingly put the plaintiff in a better position than he would have occupied had the contract been fully performed." In other words, reliance damages can never exceed expectation damages in contract law. We don't want to provide more or less than the benefit of the bargain, and reliance damages, when they would create a windfall, will not be awarded. There are, of course, complications and deviations from this, as from all our simple principles. For example, a seller might forego an opportunity to enter into a certain transaction because of relying on the transaction at hand, and this is called opportunity cost. Opportunity cost is when a seller forgoes an opportunity because they're relying in the opportunity at hand. The opportunity cost could, under certain circumstances, result in additional reliance damages. For example, a buyer may be induced to spend cash, which they could have had in the bank earning interest. Should the interest that was not paid because of reliance in receiving the product be awarded? Should courts treat unearned interest as an opportunity cost and add it to reliance damages? Courts will be hesitant to add unearned interest to reliance damages because it's speculative, although there are cases where unearned interest can be added to reliance damages. What if a buyer incurs interest charges by taking out a loan to pay for a widget, and the loan bears interest, and so the buyer is paying interest on a monthly rate, and then the seller breaches and never sells the widgets? Now courts will be more likely to consider those interest charges, which were incurred on reliance of obtaining the widget, as added to the damages calculation. There are other scenarios where reliance and expectation damages are hard to distinguish. But these are exceptions that prove our general rule. The general rule is courts will not award reliance damages when they exceed expectation damages. Expectation damages are the preferred measure of damages because they give the parties the benefit of the bargain that they struck, that they thought would make each themselves better off when they made it. Expectation damages, according to the theory of efficient breach, are the best way to make a contract efficient, and courts will apply them whenever possible. Next, we'll talk about restitution damages, which are an introduction to equitable remedies or quasi-contractual remedies. Before we go on, are there any questions about Reliance damages?